our first FedSoc event of the semester. Today we're joined by Professor Josh Blackman. I'm going to give a brief little introduction to the topic, Federalist Society, since it's our first event of the semester, for those of you who are kind of newcomers. And then we'll get on to Josh's discussion about the New York State Rifle and Pistol Association v. Bruen. It's a new case about the right to concealed carry. So without further ado, I'm going to share a brief presentation. So the title of today's event is Arms, Where Can We Bear Them? I thought it was kind of a fun, silly title about, I think the topic is very serious and very important. And again, this is featuring Professor Josh Blackman. For those of you who are not familiar with the Federalist Society, it's really a group of conservatives and libertarians, generally in law schools and legal scholarship. Again, it's really mostly just a law and policy institution, as the name suggests. But it's founded on the principles that the state exists to preserve freedom, and that it's emphatically the province and duty of the judiciary to say what the law is and not what it should be. I'm sure those of you returning, have heard that a million times. Introducing Josh Blackman. He's a professor at the South Texas College of Law in Houston, Cato Institute scholar, Georgetown Center for the Constitution non-resident scholar. He has been, I'm sure you might have seen him on a variety of news programs. I know he speaks on NPR, the BBC, Fox, plenty more. I'm sure he's willing to tell you. And one really interesting thing that I thought, and this is kind of new, is I know he said he's founded about 10 years ago, but Fantasy SCOTUS, where you can predict the outcomes and decisions in upcoming Supreme Court cases. So I think that's kind of a novel and interesting thing. But with that, I'll hand it over to Josh, and he's going to talk a little bit about the topic today. Thank you, Josh.
All right, excellent. Thank you so much to Fordham, and thank you so much for hosting me. I'm sorry I can't be there in person. I think by next semester we should all be beyond whatever we're now. It will hopefully be faded. We'll be good. We'll be happy. We can eat. We can be merry. But for now, you're stuck with a little 4x4 square of me. The topic today is the Second Amendment. The text is fairly short. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. My goal today is to walk you through the history of the Second Amendment at the Supreme Court and bring you to the present of where the court is now, and really any day now where they might go. Our analysis starts in a case called District of Columbia versus Heller. This was a 2008 decision, a very important decision, because it recognized that the Second Amendment protects an individual right to possess arms for lawful self-defense. But the court left a lot of open questions. The court said the Second Amendment is not unlimited, and it's not a right to keep and bear arms for any purpose in any manner whatsoever. And Heller walked through a lot of the history. Many of the 19th century courts who looked at this issue considered prohibitions on open carrying and prohibitions on concealed carrying. Heller tells us that at the time of the founding, the word bear means to carry. And the court suggested that this right to bear arms exists. But it didn't say where this right extends. The Heller court had no occasion to decide whether the right to keep and bear arms extends outside the home. Indeed, the court went a bit further, and they said, we do not cast doubt on certain prohibitions of carrying firearms in sensitive places, such as schools and government buildings. Again, the court said we are not here touching these sorts of long-standing prohibitions on carry bans in sensitive places. What does that tell us, right? If The government has the power to ban guns in so-called sensitive places. Then there are presumptively some places that are not sensitive, right? So Heller didn't squarely decide whether the Second Amendment protects a right of carry, but there are certain shades or hints in the opinion, if you will, that suggest this right is not limited to the home. Okay? 2 years later, the Supreme Court decided a case called McDonald v. Chicago. McDonald considered a handgun ban not in the Federal District of Columbia, but in the city of Chicago. In McDonald, the court held that the Second Amendment protects not only a right to bear arms against the federal government, but also a right to bear arms against the states, as the states cannot prohibit outright the bearing of arms at home. But again, the court in McDonald didn't really address the follow-up question. Can the state prohibit carrying of firearms altogether? Okay. So Heller was in 2008. McDonald was in 2010. We are now in the year 2012. We are past Heller's bar mitzvah, if you will, right? We are long past his 13th birthday. And we still do not have any clarity on whether the Second Amendment protects a right to bear arms in public. So as a policy matter, 40-something states allow carrying in public. I live in Texas, for example. In Texas, we have what's called a shall issue regime, which means if you apply for a concealed carry permit, the government runs a basic criminal background check. And so long as you have no overt flags, no red flags, crime, etc., you get your permit. There's no subjectivity. Right? The government doesn't decide, well, Josh, do you really need a gun? Maybe you're going to be whatever. If you meet the standards, the objective bright line rules, you get your permit. About 8 or 9 states, including New York, New Jersey, and a couple other East Coast states, have what's called a may issue regime. A may issue regime. Okay. What does that mean? The government may give you a license if they decide you have a sufficient need. A sufficient need. What does that mean? Well, it's not enough to say you have a right to self-defense, right? To defend yourself. That is not sufficient. Rather, you must prove some specific need that puts you on a different level than the rest of society. Okay. This standard is very hard to satisfy. Most people in New York, and I'd say New Jersey as well, do not meet this standard. It's also very subjective. If you are friends with the sheriff, if you're politically connected, if you're a celebrity, you have a very good chance of getting one of these permits. But if you're a poor, random person like me, especially me, and you frustrate the government at all, you may get no permit. For many years, the regimes in New York and New Jersey were being challenged in the courts. And the New York and New Jersey courts upheld these restrictions uniformly. The courts held that Heller did not decide there was a right to bear arms outside the home. And even if the Second Amendment does protect a right to bear arms outside the home, New York's regime fits within it. That is, there's no absolute right to bear arms, and the government can decide how much you really need this weapon. Right? The challenge is that no, that's not how gun rights work. Right? That's not how gun rights work. When you have a right, the government bears the burden to say why you shouldn't have this gun. it's not the job of the individual to say, I have a right, and here's why I get to exercise it. Rights usually don't require justifications by the private citizens. There's a good tip for you law students. In any constitutional litigation, if you're the party that bears the burden, you're probably going to lose. Whoever bears the burden usually doesn't have enough evidence. About 2 years ago, a case came from New Jersey challenging New Jersey's prohibition on carrying. The Supreme Court denied review. They said, we're not going to hear it now. Justice Kavanaugh and others suggested that the court should take a case soon, but there still were not the votes to do it. Fast forward to September of 2020, and Justice Ginsburg suddenly passed away. She was replaced by Justice Amy Coney Barrett, the third Trump appointee. And with that, there was now, on paper at least, a solid 6-vote majority for the conservatives. And at long last, the Supreme Court finally took a case that could clarify whether the Second Amendment protects a right outside the home. This case is called New York State Rifle and Pistol versus Corlett. It was Bruen, but Bruen's no longer there. And the Bruen case the Corlett case discusses whether there is a constitutional right to carry outside the home. And there's a lot of historical evidence here, and I'll walk through some of it with you. So far, most courts have adopted a test that really weakens the Second Amendment, right? There's this 2-step test you'll see in a lot of cases, right? The first is the courts ask, is this activity protected by the Second Amendment? Regardless of the first step, they go to the second step, and they apply a form of heightened or intermediate scrutiny, depending what they call it. And virtually every gun control regulation survives this standard. And the reason why is what we call interest balancing. We all agree and we can admit that guns can be quite dangerous, right? The usual reason why you have a gun is because it can shoot something and kill something. So the courts basically presume that these guns are dangerous and they can be used to hurt others. And therefore, the government has a good interest to restrict them. And once you get to that sort of conclusion, virtually any sort of gun control law will stand. Because again, the burden is put on the individual to justify their right. Only a couple courts have held that the Second Amendment protects a right outside the home. The Seventh Circuit did it in a case called Moore versus Madigan, and the D.C. Circuit did in a case by then Judge Kavanaugh. But for the most part, the courts have upheld prohibitions on public carry. Okay. Now let's walk through some of the historical evidence in support of this right to bear arms. We can start in 1689. The English Bill of Rights created this right of resistance and self-preservation, this right to bear arms itself. The English Bill of Rights, though, was limited to people of certain religion, which is not what we have here. But this shows that even outside the context of the militia and anything else, there was a history and tradition of protecting the right to bear arms. Another statute that often comes all the way back in 1328. Yes, almost 800 years ago. 700, I can't do math. Almost 700 years ago, in the year 1328, the Statute of Northampton. This statute limited the carrying of arms in public. But in my view, at least, it only restricted carrying the guns in dangerous and unusual ways that will cause terror to the people. And that there were a number of decisions of courts in England that read it this way. So merely carrying pistols to church would not violate the law because you could secure yourself. it was using them in a threatening manner. During the colonial founding era, many of our founding fathers carried guns publicly. People like George Washington, Thomas Jefferson, John Adams. James Wilson, who served on the U.S. Supreme Court in the 1790s. He wrote that people have a right to carry arms for self-defense. And Wilson thought that only carrying them dangerously would be prohibited. In 1822, the Kentucky Supreme Court considered a law that restricted carrying of concealed weapons. The court said this law was unconstitutional. In 1846, the Georgia Supreme Court said that the right to bear arms exists, and the state could not restrict public carry. Now, this may surprise you, but the first gun control laws were actually enacted in southern states. And they were enacted in the wake of the Civil War. You might guess why the southern states were trying to restrict the carrying of arms. For the freedmen. Many southern states restricted carry to ensure that the freed black citizens could not defend themselves, to make them basically vulnerable to mobs and the Klan to destroy them. So some of the earliest gun control laws were about suppressing the rights of the freedmen to bear arms. During Reconstruction, many of the federal government officers in the Union Army said that the freedmen cannot be deprived of the right to bear arms. So when we look at some of the earlier gun control laws and interpreting them, we have to consider race, right? That much of this law was not about restricting gun violence, but about punishing the freedmen. And keep that in mind. Okay. Another couple pieces of history from that period. In 1866, Congress passed the Freedmans Bureau Act. The Freedmans Bureau Act. Very important legislation. This law protected the rights of the freedmen. And the law said it applies to all citizens, regardless of race, color, or servitude. This law expressly declared that the right to bear arms was a fundamental right. In 1871, Congress passed the Ku Klux Klan Act, the KKK Act. What we now know as Section 1983 began in the Ku Klux Klan Act. And the drafters explained the law was a means to enforce the right to bear arms in the public. It concerned those who go on public highways, right? This was a right not limited to the home. And even if you think that the right in 1791 might have been limited to the home, by the time you get to the 1860s, this right had expanded far beyond home carry to a right to carry on public places. Now let's turn to the New York law for a few minutes. The current New York law was enacted almost 100 or over 100 years ago. In 1911, New York enacted what's called the Sullivan Law. And the purpose was pretty blatant. It was designed to deny the right to bear arms to foreign-born individuals, specifically Italians. Good thing you had a good Jesuit school, right? In the first 3 years of the Sullivan Law, 70% of the people arrested under this law had Italian surnames. So this was obviously a discriminatory law. The Sullivan Law lives on today in New York's law, and it's still a crime to possess a firearm without a license outside the home. This is a statutory violation. It's a Class E felony. Up to 4 years in prison, up to a $5,000 fine. And possessing a loaded firearm outside one's home can be a Class C felony, up to 15 years in prison. This is a very big deal. Indeed, several public defenders in New York actually filed an amicus brief in support of the challengers. They argued that our clients being prosecuted for these laws, which would be unconstitutional. These public defenders were dragged on social media saying, "Oh my God, how dare you? Aren't you supposed to be progressives? And how can you favor guns?" Well, look, if any of you do public defense work, you have to realize if there's a law, it's going to be enforced. And it's not going to be enforced evenly. Black and brown people will be prosecuted far more for these crimes. So good for the public defenders for standing up, and shame on those who are dragging them on social media. It's how these dreadful things go. Under the current law, you must demonstrate proper cause for a license to carry outside the home. But proper cause is not defined in the New York Penal Code. Courts just made the standard up. People need to demonstrate a special need for self-protection that's distinguishable from that of the general community, right? You need a very special reason. The desire to exercise a fundamental right in a high crime area is not enough. So even if there's crime in your area and you're maybe facing possible threats, that's not enough. People whose jobs require them to carry a large amount of cash in high crime areas still denied licenses. The NYPD requires a showing of extraordinary personal danger, documented by proof of recurrent threats to life or safety to show proper cause. And even if you meet all that, you'll still lose, because the courts will only set aside a denial if it's arbitrary and capricious. In this case, Nash was one of the petitioners. He passed every background check and met every other qualification. And Nash is actually allowed to carry a handgun outside the home for hunting and target shooting, but not for self-defense. So think about that one, right? There were robberies in his neighborhood, and he completed advanced firearm safety training, but was still denied because he didn't have a special need. So he carries the gun for target shooting and hunting, but not for self-defense. So he can be, I guess, he can save himself from a bear, but not from a robber. The other petitioner, his name is Coach, has a license to carry outside the home for hunting and target shooting, but not for self-defense. He has extensive training and experience, but he still is denied. The district court and the Second Circuit ruled for the government. The lower courts held that the proper cause requirement falls outside the core Second Amendment protections in Heller, because it affects ability to carry only in public. The court used intermediate scrutiny, and they deferred because there's a basis for public safety. This case was appealed to the Supreme Court, and the Supreme Court granted review. The argument's pretty straightforward, right? The reference to bearing arms in the Constitution secures a pre-existing fundamental right to carry weapons in case of confrontation. At the founding and today, the need for self-defense was hardly limited to the home. The English right, which the Second Amendment was based on, was uniformly understood to protect the right to carry ordinary arms for self-defense. It was commonplace in early America. This belief was upheld when Congress acted to ensure freedmen could bear arms to protect themselves just like any other citizen. New York's law criminalizes the exercise of a fundamental right and cannot survive under any standard of scrutiny that the court applies to enumerated constitutional rights. So let's start with the text. Keep and bear. Keep and bear. These are two distinct rights, and we should not collapse them or merge them into a single right, because that would waste words and create a surplusage. Keep arms was a common way of saying possess arms, and bear arms meant to carry. Bear arms also imply that you carry for a specific purpose. For example, bear arms in a coat, bear a sword, and in this case, bear arms. This refers to some conflict perhaps outside the home. We also looked at history and tradition. Heller recognized that the Bill of Rights in 1869, the English Bill of Rights, was understood to protect individual right, protecting against public and private violence. And even before the Bill of Rights, there was protections for Protestant Englishmen for firearm defense, and it was not confined to the home. No colony or state in the early republic affirmatively prohibited people from carrying firearms openly or concealed. Some states affirmatively encouraged required carrying, but early restrictions only targeted conduct that terrorized the public. In 1843, the North Carolina Supreme Court said that carrying of a gun per se constitutes no offense. In 1822, the Kentucky Supreme Court invalidated a prohibition on concealed carry as a violation of the Second Amendment. In 1833, Tennessee Supreme Court said freemen have a right to keep and bear arms and will go far to prohibit the carrying of weapons entirely. In 1840, the Alabama Supreme Court said that legislatures can inhibit citizens from openly carrying because the Constitution authorizes them to carry for the purpose of defending himself and the state. 1850, Louisiana Supreme Court upheld concealed carry restrictions only because the state guaranteed every citizen the right to carry openly in full view. Decisions that suggest that people may not have a constitutional right to carry handguns relied on erroneous premises that the Second Amendment protects only military arms and not individual right to self-defense at all. In the antebellum period, after the war, Congress and the public debated whether and how to secure constitutional rights for newly freed slaves. These debates confirmed the widespread view that the Second Amendment secured a right to carry arms for self-defense. The Freedmans Bureau Act of 1866 specifically identified constitutional right to bear arms and not just keep them. The Ku Klux Klan Act, 5 years later, specifically targeted those who go in disguise upon the public highways of another. Violence was not confined to the home. Now, New York has other restrictions, right? New York's approach criminalizes the exercise of a fundamental right, and that right belongs to the people, which means all members of the political community, not an unspecified subset. The Second Amendment is for law-abiding citizens as a rule. New York turns this restriction on its head and prohibits almost all restrictions for law-abiding citizens. The Supreme Court would not hesitate with a law that reserved the First Amendment rights to those with an unusually compelling need. So imagine you can only have a protest if you have a really good justification for it. Or a Fourth Amendment right for those with a special need for privacy, right? You can only have a freedom from search and seizure if you have a good reason. Or imagine if you have a right to abortion. You only get abortion with a really good justification. Maybe you just not wanting the baby is not sufficient. New York's regime is even more disturbing because the proper cause standard is left to broad discretion of a government official. The Bill of Rights is supposed to protect individuals against government, and this regime reverts a right into a privilege. There's history also. The regime was originally put into place to disarm newly arrived immigrants, especially Italians. This history is well known and supported. The Second Amendment analogized that a ban on carrying handguns at all is similar to laws prohibiting the use of firearms on certain occasions and in certain locations. But that's like saying because the government can prohibit defamation, it can also prohibit speech criticizing government officials, right? Banning in sensitive places is different than banning in all places. The Second Amendment also noted 19th century laws that ban concealed carry. There are these laws that exist, but at the same time, states permitted open carrying. I wonder if New York was put to a choice. Would you allow concealed carry permits or give everyone a right to open carry? I think people in New York would freak out with open carrying. I'm not a fan of it, but I think there has to be some option to carry in public, whether open or concealed. I think New York, if push came to shove, would say, okay, conceal. We're not going to let you open carry. The Supreme Court has clarified that intermediate scrutiny does not require that laws be the least restrictive means of achieving their ends. But the law does need to be narrowly tailored to achieve the government's interests. In this case, the petitioners can carry a handgun outside for target shooting and hunting, but not for self-defense. This doesn't make any sense. Banning typical citizens from carrying any type of handgun anywhere, unless they can distinguish themselves, is not a serious effort to avoid burdening substantially more protected conduct that is necessary to further legitimate governmental interests. So now we're here, March 14th. The Supreme Court will probably decide the New York rifle case at the end of June. My prediction, which is not worth much, my friends, you get what you pay for on Zoom. My prediction is that the Supreme Court rules against New York. I don't know on what grounds, though. The court could adopt a text and history approach. The court could say that this law fails under either strict or intermediate scrutiny. They don't need to decide which one. But what's important is what comes after this case. Even if concealed carry is allowed in these 8 or so states, you have other challenges in the wings. For example, prohibitions on various types of long weapons might be called assault weapons by some people, right? High capacity magazines. A huge issue is actually felon disenfranchisement. If you commit a felony, you're basically barred for life from owning a firearm. So even if you're a non-violent felon, think of like Martha Stewart, you still can't own a gun. So there are a lot of lingering issues. So depending what standard the court picks here, it can go in many different directions. But those are all the prepared remarks I have. I'm sorry Professor Johnson can't attend our event today, but I'm sure we can answer some questions to keep a lively discussion. So thank you so much, and I look forward to hearing from you.
Thank you, Josh. Everyone, you're free to ask whatever questions you want. You could either use the Q&A function or you can raise a hand. Either is completely fine. But while you think of questions, I see we actually have Professor Griffith raise his hand, so I'll allow him to talk. Hi, Professor Griffith. You're muted, but you're here.
Hi. Okay. Oh, there I am. Okay. First of all, I want to thank Professor Blackman for doing this. Thanks very much. I really appreciate it. I just want to ask a question. You were alluding to some stuff towards the end of your remarks. I live in the state of New Jersey. It's with a 10 shot magazine capacity rule, and I've been wondering what the basis of that is, and when that gets challenged. And you alluded to this at the end of your remarks when you said, depending upon the standard that the Supreme Court adopts in reviewing the New York case, it might have implications for the various assault rifle bans and the high capacity magazine laws in various states. I wondered if I could just ask, this is really an informative question for me,
Sure.
to spell that out a little bit more so that if the Supreme Court were to decide the New York case on a strict scrutiny, higher scrutiny standard, that standard presumably then would apply to other laws like the high capacity magazine rule and so on. Was that the reasoning?
Sure. Yeah, and thanks so much for the question. I appreciate you're watching along on Zoom. Again, hopefully next year we can hang out in person. It'd be much nicer. Right. So there are a couple parts to the question. The first was about the capacity magazine, the high capacity magazine ban. When I talked to a group in New York, I presume you don't know anything about guns. I grew up in Staten Island. I didn't touch a gun until I was about 25 years old, so I presume the same. Most handguns, most semi-automatic handguns come with a magazine. It's like a box where you put the bullets in, a container. And most magazines are between 12, 14, 17, 20 bullets can fit in, 20 rounds, as we would say. California, New Jersey, New York, and a couple other states have restricted the size of the magazines to 10, or in some cases 8, depending on the state. The reason for that ban, and just follow my reasoning for a minute, is to encourage more time between reloading. So imagine someone's engaging in a mass killing. They empty their clip. As they fire all 10 bullets, they need to pause, drop out the old magazine, load in the new magazine, pull the slide back, and resume shooting. And the thinking is that in between the dropping the old magazine, putting the new one in, there might be an opportunity to intervene and to stop the shooter, right? So if you limit it to 10 versus, say, 14 or 17 or 30, there's more of a chance to stop the shooter in between. That's the rationale. Some states have put very low restrictions for magazine size. And the challengers have said, well, that's all well and good, but sometimes self-defense actually requires 10, 15 rounds to handle whatever the situation is. There was actually a trial court in Buffalo, a district court in Buffalo, New York, upstate New York, that declared the New York handgun magazine, the magazine ban, unconstitutional. The Second Circuit reversed that, and then I'm pretty sure the Supreme Court denied review. I can't recall for sure, but I think they denied review on that one. So that's the rationale there. And again, they sort of upheld the restriction under, they call it heightened scrutiny, whatever you want to call it. Now, to the second part of your question, how does the New York State rifle and pistol case affect other potential areas? For example, felon disenfranchisement, these high capacity magazines, these sort of assault weapon bans. A lot depends on what opinion the court writes. The court could simply say, as a matter of text and history, there's a deeply rooted right to carry outside the home. We do not need to decide the scrutiny question. That's entirely plausible. That's in the realm of possibility. And if the court goes down that road, it's possible that not much changes in other areas of the law. That just in these 9 or 10 states that prohibit a concealed carry, things change and everything else stays the same. The court could say that New York applied the wrong level of review, which is also a possibility. The court might say New York adopted a sort of very deferential intermediate scrutiny. No, you need to apply something closer to strict scrutiny. It has to be narrowly tailored, at least restrictive means. That, I think, would have collateral consequences and affect other facets of how this process works. I'm sorry, Professor. There might be more questions. I think I forgot the other parts, but anything else I can inform you on? I'm sorry.
No, I think you got it. You got it. That was really it. So the idea is that the level of scrutiny, just so I can recap the last part. So the second part is really what I was after. The level of scrutiny that would have been applied by the lower court in the New York case would have been a form of intermediate scrutiny that was too deferential. And then if the Supreme Court addresses that aspect of the case and insists upon a heightened standard of scrutiny within, you can call it intermediate or whatever you call it, but if it's clear that the scrutiny that's required is higher, then you might wind up with more change in those other areas, including high capacity magazines or felon convictions and so on. Is that right?
I think that's exactly right.
Great. Thank you so much.
I see we have another question from Brandon Chesner. We'll open that up. Oh, sorry. I don't know if these are I don't think these are supposed to be anonymous. Yeah, no, they're not. Anyway, Brandon, thanks for the question. Do you see it, Josh, or do you want me to read it?
Would you mind reading it? Hold on.
Yeah, absolutely. Absolutely. What do you say to people who think of the Second Amendment right to bear arms would only apply to, quote, members of a militia, end quote? So the question is, what do you have to say to people who,
Right. So the Second Amendment is sort of a tricky piece of text. You have these two parts, right? It provides a well-regulated militia being necessary to the security of a free state. Okay, that sounds all about militia. Then you get the second part. Then it says the right of the people to keep and bear arms shall not be infringed. Right? So this creates a tension, right? The first half of the sentence seems to be discussing the militia. And the second half of the sentence seems to be discussing this right to bear arms. The analysis gets even more complex because we're not just talking about the Second Amendment, we're talking about the 14th Amendment. Right? Heller was about the Second Amendment as regarding the federal government, right, in D.C. But the New York State rifle case, which we're talking about today, concerns the Second Amendment as applied, or we say incorporated, through the 14th Amendment. So let me answer your question the easier way, sort of the cop-out way. Even if the Second Amendment in 1791 concerned the militia and the British and other good stuff, by the time you get to the Civil War and Reconstruction, there were no more redcoats, right? We weren't fighting the Brits. The Second Amendment expanded. And it was quintessentially right about self-defense, particularly defending yourself against both private and government violence. So even if the Second Amendment had a meaning in the 1790s about a militia, which it probably, I don't think it did, but let's just say we did just for argument's sake. By the time you get to the 1860s, it's a much broader right. So there are a lot of scholars who maybe think Heller was wrong, but McDonald v. Chicago is correct, which is why McDonald's a 5-4 case. It really shouldn't have been. That should have been much easier for the court. But merely saying the Second Amendment is not about militia individual right doesn't tell you what it actually means, though, right? it's not self-evident that the New York may issue regime is unconstitutional. I think it is. I think it turns a constitutional right into a privilege. I think it's problematic, but that's not self-evident. Brad, does that answer your question?
Brandon, you can respond just through the chat if it has, but regardless, okay, there you go. Yeah, I said yes, thank you.
Okay.
I actually do have a question. Of course, I'll always yield if. Oh, actually, there's another question from an.
Hold on, I see it now. I can read it. Okay. Thanks, Professor Blackman, for your time. Throughout the past several years, some gun control advocates have argued that fingerprint recognition technology that limits use of guns to its original owner could assist in curbing gun violence. Do you think that a requirement that all guns possess fingerprint technology would infringe on the right to bear arms? Okay, so the question is about fingerprints. So there are some models of guns that exist that will only fire if the person holding it has the right fingerprints. There's a fingerprint scanner right on the handle of the gun, and you basically put your finger there. It recognizes who you are and then authorizes you to pull the trigger. There are other ways of doing this. They have these sort of smart RFID tokens where you wear a special watch, and the watch has to be in a certain proximity to the gun, or else it won't work. So I usually answer this question perhaps a little bit snarky, but I'll try. I'm sure a lot of you have iPhones or Android phones, right? And you know your iPhone is a fingerprint reader. How often do you put your fingerprint there, it doesn't read the first time? Happens to me quite a lot. Maybe it's hot outside, your finger's sweaty, you have some schmutz on your finger, right? It doesn't read it. How often do you look at the iPhone thing and it doesn't recognize you right away? Right? These technologies are not perfect, right? They might be very accurate. On the iPhone, you probably know you can actually swipe up to take a picture because you can't always get to the camera app quickly enough with your fingerprint. Apple at least recognizes that this technology is not always perfect. Having a gun for self-defense often is a matter of a split second. You may not have the time to sit there and keep jamming your finger on the fingerprint reader if you're about to be attacked, right? Or trying to locate some RFID bracelet to activate your gun. So I think even the technology itself is problematic because it injects a layer of software, which is not reliable in self-defense, right? These are not reliable tools. I would much rather have something that's mechanical, that is not dependent on battery life, right? If the battery dies in your gun, it's useless, right? A self-defense weapon needs to have much more flexibility. Now, that's a policy answer, right? You're asking as a matter of the Second Amendment. I'm not sure that the rationale for these sorts of policies really is necessary. If the concern is having your gun being used by someone else, locks and other things may be useful. Of course, you can just take someone and say, put your finger in the gun and then take it from them, right? How much scrutiny do we actually need to pull the gun control measure? But yeah, I think as a policy matter, these devices are very bad ideas. I mean, look, the people who are designing things are not actual gun owners, right? Gun owners don't want these. They don't need them. If they want them, they can have you can buy a fingerprint lock for your gun, right? I was buying a gun safe, and I considered buying a gun safe that worked with my fingerprint, and I decided against it because what happens if the battery dies, right? My gun's trapped, right? What happens if my finger is sweaty or it's dark and I can't figure out? So I have a combination lock. I can do it in my sleep. It's very easy to open. It's like 5 buttons. And you just push a combination. It's very easy. And it's mechanical, never break. I hope it doesn't break at least. That's my answer to that question. But good question. What else is on your minds?
Well, in the meantime, of course, anyone can always continue to ask questions. But I have a question about. I know you mentioned the statute of Northampton, and I know that came up a lot in oral arguments.
It did.
I was just kind of curious, what is it about this? I mean, to me, it seems right like it's just this very archaic statute, and it would be pretty much meaningless. Why does it carry so much weight in these arguments?
I don't know. I mean, look, it's an I keep saying 800 years. It's a 700-year-old statute, right? It's 700 years old. We have so much history that comes after it. I think what the supporters of gun control laws are showing is that there's a long history of restricting arms, but we have the English Bill of Rights. We have The Freedmans Bureau Act, so much stuff comes more recently than what happened in English 700 years ago. I think it might warrant a sentence or two in the opinion that's it. I mean, it seems pretty. I mean, we often cite Magna Carta, which is 1215, which is a little bit older, 100 years earlier, but at a high level of generality, not like, well, whatever's, whatever, feudalistic rights were allowed in Magna Carta, that's it. We're frozen. That's it. No one ever argues that, even on our side.
And I do have another question, actually, about, I think it's more about gun culture, especially in blue states, like, or I shouldn't say blue states, but I guess there's kind of an overlap, like, in states like New York and New Jersey, where firearm restrictions are a little bit more heavy. Let's say your prediction about the Sullivan Law is true, and that the court kind of shoots down the May issue permit scheme. What do you think happens in states like New York, especially a place like New York City? I know that they were very concerned. The party itself is very concerned about public carriages and subways and that sort of thing. I mean, what kind of restrictions do you see following, if indeed that happens? I'm sure they're going to probably, there's other restrictions that are going to pop up in terms of where you can carry and that sort of thing.
Yeah, I mean, look, I hate to break it to New York, even if, I'm sorry, man, my microphone dropped. This was not the mic drop I wanted. Even if the court rules in favor of the New York Rifle Club here, it's not going to be easy to carry Manhattan, right? Every single building will put up a big sign saying no carry allowed. Every school, every subway will have no carry allowed. Most private sidewalks, no carry allowed. It will be a trap to walk into Manhattan strapped, right? You're going to be trapped somewhere. It's very hard to exist in Manhattan without going to some sort of place where it's going to be banned. Upstate New York might be a little bit easier, right? There actually may be corners of the state that would allow it. So I don't think things change radically in New York City. The question of where guns can be banned is actually very tough, right? So at the argument, they asked, what about Yankee Stadium with 60,000 people crammed into a baseball stadium? What about the New York City subway, where you're in New York, you're crammed in inches away from someone else, and it's very hectic. And come on, people in New York already have guns in the subway. Come on, let's be realistic here. They're all carrying anyway. It's just not the good people are carrying, right? The bad guys always have guns. What about college campuses? Does NYU have a college campus? Does Columbia have a college campus? What about a state university in New York? They do exist. CUNY, oh my goodness, where I was protested, right? It's a city university. In Texas, we have campus carry in public schools. It's been in effect now for 4 or 5 years, and the world hasn't ended, right? I think things magically. I mean, professors were resigning after this came up, saying, "Oh, I don't want to teach in school with guns." And okay, we kind of moved past it, right? It's kind of like masks. You just eventually get over it, right? Sorry, too soon. So look, the world's not going to end. People with carry licenses tend to be very responsible. They're not the ones engaging in crime. And maybe they're in the right place at the right time to defend themselves. It's possible. So I don't know.
If anybody, again, feel free to ask any additional questions or raise your hand or anything. I'm sure somebody out there has a question.
Is Lincoln Center a sensitive place? That's where you guys are. You're in Lincoln Center, right? If I remember correctly? Yeah.
Yes.
Yeah. Probably sensitive place.
Probably will be. I see we do have another question.
Okay, I see that one. Are there any states who currently allow concealed carry that require a gun safety course? In your opinion, would a gun safety course prior to concealed carrying be unconstitutional? Most states actually do require a gun training course for concealed carry. Texas used to, and they actually got rid of that. Now it's just Texas has now it's called constitutional carry, which basically means anyone can carry so long as you're not a criminal. Texas had for the longest time a shallowsh regime that required you taking a class. I took the class. It was fine. It was a couple hours long. You had to spend some time in the shooting range. You have to hit a target at a certain distance with a certain accuracy, like there was a target to hit a certain point in the target. It wasn't terribly onerous. I mean, look, again, this might sound shocking. Most people want to carry a gun, already know how to do it, right? They've already been shooting for some time. You don't just wake up and say, I want to carry a gun, right? People know what they're doing for the most part. Would a training course be unconstitutional? I don't think so, so long as it's not too onerous. The part that may be bad is the fees, right? Because what happens if New York says the fee to apply for a handgun license is $10,000, right? That's not a fee to cover a bureaucratic administrative cost. It's just designed to deter people to carry arms. So I think the fees is more significant than the training class, right? And in this case, our people are the plaintiffs, petitioners. They took every class that exists. They have perfect proficiency, so that's not going to be a problem. But the fees might be. New York may try to make this a very expensive proposition. They have to renew every year, take a class every year, renew every year. That may become too onerous, right? I mean, with driver's ed, we take it once and never again, thank God, right? With your driver's license, was it 5 years, 6 years? I don't remember what it is in New York, but you don't have to pay it every year. But New York may try to make it every year you take a class, pay an exorbitant fee. That may be too much. What else you got, Fordham?
I'd also like to ask, kind of jumping off that question, is there any situation in which out of courtlet we get, I guess the dismantling of the permit schemes in general? Or do you think that, I mean, at the most the court is going to do, like, is there any legal avenue to go past even something like must issue? Or do you think that we shall issue, whatever the terminology is? Or do you think that if the court goes that way, there's really no way to go beyond the shall issue situation?
I think Brandon just put a very similar question to the chat. So
let's see. Let's just handle his question.
No, you asked basically the same question, right? So here's the question: if the may issue regime in New York is unconstitutional, is the only alternative shall issue? I think the answer is probably yes, right? New York can still impose a host of objective standards, gun safety courses, background checks, fingerprinting, all these other sorts of nonsense, right? But what they won't be able to do, I think, is impose a subjective test of, do you show sufficient need, right? Do you show a sufficient justification, a particular justification? That's not going to be allowed. If you're a former police officer, oh yeah, you're good, right? But if you're just a random person, a regular person, you're not going to get it. I think that's gone. So I think starting in June or July or August, maybe, every New York City resident, every person in New Jersey can, in theory, apply for a permit. And so long as you meet the objective criteria, you'll be fine. It might take a while, though, to actually draft up the regs, but I'm sure they're already working on it. They're going to make it hard. Look, I mean, New York's not going to make, let me say this like this. Texas wants to make it very hard to get an abortion. New York wants to make it very hard to get a gun. Nothing the courts do will change those two facts. That's just the way we live. If you guys want, move to Texas. We're welcome to have you. It's a big state. Plenty of people can come on by and just leave New York behind. You don't need to be there anymore. I grew up in New York. I visit my parents. I love visiting. I do not ever want to live there ever again. All right. And I think I don't see any more questions.
Audience, it's your last chance. If you have any burning questions.
All right.
It doesn't look like it. Well, yeah, that's just a thank you coming in the chat.
Thank you so much.
Yeah, thank you so much. We really appreciate it. I mean, this has been a very informative talk, and you've been great with the answers and handling the questions. And obviously, you are incredibly well versed on the topic. It's pretty clear. So thank you for great presentation.
Thank you so much. All right, everyone, take care so much and have a wonderful day.
You too. Thank you.
Recording stopped.